Okay, abusunya be makwa ba sonko so edeba Ghana politics avenue. So abusunya yembunra yensem breaking news bi abaye no ene a project ede ato ye screen no enchen ede amamno former NSA director or say SB entry granted bail of 800 million Ghana cedis with 6 sureties to be justified. He is to be placed on Ghana Immigration Service stop list. Abusunya or say SB NSC no ya granting the bail with 800 million Ghana cedis with 6 sureties as you see no ne passport and so no Ghana Immigration Office for so no omode omunsa atoso a abusua enye asam keto akra yensam mre mom yankọ na yankọ nkotie ensam bia e course unsubscribe ya subscribe like na share ma afoforo so ensa entumi enka bia ha Ghana politics avenue so political trending stories are make waves no yenso ya atum se de bebrem medamase
3FM 92.7 for those of you who are on the road right now. So it's probably brought to you by Flamingo Paint, Simple Superior, Sasso Insecticide Spray and Coil, Kum Tum Tum Precom. Coming up next here on Ghana Tonight, the Supreme Court loses out that particular steam of the bid to stop the trial judge in the Addo case. Well, tell us. We'll tell you exactly how this team was lost as the Supreme Court threw out that challenge brought against this particular process by the lawyers of the former National Signals Bureau, led by Samuel Atachia. They've expressed disappointment over the decision of the Supreme Court regarding an application seeking to stop the trial judge from hearing this criminal case against Kwabena Addo, the former National Signals Bureau boss. Now, the Apex Court unanimously dismissed their application to prohibit the trial judge from further hearing the matter. Now, I wanted to take a listen to exactly what Samuel Atachia said. As a lawyer, the lead counsel for Kwabena Addo, he was not too happy, as was expected, about this particular decision by the court earlier today. Take a look.
Disappointed but not discouraged. We'll see how the case will travel.
How does it feel going back to the same court that you...
It doesn't move me at all. The only persuasion a judge will have is the law. I'm not going to have a banter with him. I'm not going to fight him over anything. I'm just going to project the law. It doesn't move me at all.
The full reasoning of the courts.
Well, clearly, not too happy about the outcome of the court decision earlier today. But this is one case that Dennis Baberi Esquire is joining me right now. It's quite clear that there is a path of having this case head as expeditiously as possible. If you recall, Daniel Yademelovo will recall that particular position that he espoused, that there should be some time limit to some of these cases that the state has brought against this person, so we don't have to drag it for so long, 8 years, 6 years, and there's really no end to these cases. So we'll be finding out exactly how these proposals will play out, and especially because of these developments that we are seeing in court and matters arising. And in fact, earlier today, if you recall, sometime last week, Samuel Atachia walked out of court because he was not happy about the proceedings and how things went, and that also drew some criticism and divergent views as to whether a lawyer can walk out of the open court like that. Dennis, and this is what we are seeing: a unanimous decision. Yes. Dismiss the application to remove the trial judge.
Yes.
How's it playing out now?
But the recall of the walking out of the learned counsel for the accused persons is a good starting point for this, because the reason for the walkout had everything to do with this particular application that was determined today. And the context is that when they appeared before that court that very morning, they had filed this application which was pending before the Supreme Court. Mm-hmm. So they had to bring to the attention of the trial judge that they had a pending application which was seeking to restrain him or to prohibit him, so to speak. And in that regard, they were praying for an adjournment so that they would deal with this matter today and then come back to continue the trial. Mm-hmm. That did not find favor with the court. In other words, the court did not grant that prayer. And that was the reason for which the learned attaché had to do whatever he did. And in fact, today before the Supreme Court, he brought that to the attention of the court and did indicate that he was constrained under the circumstances, and that was how come he had to take that particular move. But however, the matters that were before the Supreme Court were pretty much simple. That's having looked at the conduct and some of the utterances that the trial judge had made in this trial so far, the accused persons think that the trial judge is biased, for which reason they were seeking the Supreme Court to restrain or at least to stop him or take him out of the case from further hearing the case, because they do not think that with him doing the trial, they will get justice. And the basis for what their claims, of course, they had to justify why they were saying so. So they made references to some of the pronouncements that the judge had made in respect of some applications that they had made. Recall that Attaché had made an application on behalf of the accused persons for some disclosures, asking that the prosecution should furnish them with some documents. According to them, part of that ruling, the trial judge actually indicated that that application was an abuse of court processes and that the information they were asking for would not assist the court in arriving at its decision. So for them, those comments made by the judge in themselves were prejudicial because their contention was that they were asking for disclosure of certain documents that the trial judge had not seen. So on what basis then was the trial judge then saying that the documents will not assist the court in arriving at its decision? So in their view, such comments already prejudged the matter and do not think that with him in there, they would get justice. There was another issue that they raised, which in their view amounted to bias. That often, when the court sets a date for a certain ruling, there's usually a prayer from prosecution to abridge the time. So he gave a specific instance where the court had given a 24th day to deliver a certain ruling. But that upon the prayer of prosecution thought the 24th was too far and that the trial needed to be expedited. So prosecution proposed 17th instead of 14th, and that prayer was granted. In their view, that amounted to bias.
I see.
So those were some of the things, including even their request for that disclosure to be made. In their view, that disclosure meant that there was information enough for the accused persons to be able to use the word loosely, prove their innocence, even though the accused doesn't prove. But in this context, it will help the accused get out of this trouble. And to the extent that the court did not allow that disclosure to be made, that in itself was a problem for them. So basically, that was the crux of the accused person's case before the Supreme Court, hoping that all of that put together, the trial judge will be prohibited from further hearing the matter.
Which the Supreme Court has dismissed.
The Supreme Court has dismissed. And of course, that was upon the opposition by the prosecution, which was led by the Deputy Attorney General, Dr. Shrimsai, in that particular regard. I mean, for him, he believed that whatever that was said, in the first instance, to correct the record, that whatever documents that they filed before the courts were not documents that they got in their entirety and decided to remove some of the documents, as the accused person's lawyer sought to portray. He simply made the point that they applied for certain documents because the act alleged to be committed, or the theft alleged to have been committed, happened within a period of time. So they only applied for the documents within that period of time, and then they filed same. So it's not the case that they got all the documents and decided to remove some of them.
See.
He also makes the case that because the judge made a pronouncement within his jurisdiction, if there was any remedy for the accused persons, it had to be by way of an appeal and not by way of a judicial review or this kind of process. So by and large, on the totality of it, looking at the evidence before the courts, including submissions of counsel, the court came to the conclusion that no, the application did not have any merit.
So the trial judge stays?
Yes. So what it means is that essentially the trial judge stays. Learned counsel Attaché would have to go back to that court and then they'll proceed. So that's how come you hear him say that he's disappointed, but they soldier on regardless.
Let's take a listen to him again. It defines the posture and the response to exactly what Dennis you've carefully and expressly elucidated there and in the proceedings in court earlier today. This is Atachia again. Take a look.
I'm disappointed but not discouraged. We'll see how the case will travel.
How does it feel going back to the same court that you...
It doesn't move me at all. The only persuasion a judge will have is the law. I'm not going to have a banter with him. I'm not going to fight him over anything. I'm just going to project the law. It doesn't move me at all.
The full
Well, so that's Samuel Atacha there. So they're going back to the court with this same trial judge that they raised some prejudice against.
Yes.
And when is the next date for this case?
Trial continues somewhere next week. What it means is that prosecution will continue to keep its witness in the box, because mind you, where the confusion erupted was the fact that prosecution having put a witness in the box was about tendering in some documents to which the accused person's lawyer Tacha, raised an objection. That's also raised another debate altogether, or an argument, for which the court had to make a determination as to whether the document should be admitted or not admitted. The judge ruled in favor of prosecution that the documents be admitted. So what it essentially means is that when they go back to court, they are going to continue from where they left off. Once the evidence is admitted, they continue with cross-examination, and that's how the case will progress in the coming days.
Well, it's one that we'll look at quite closely, and this is not the only one. From the National Signals Bureau case, that's the NSB, let's go to NSA. That's the National Service Authority. This is another case that is also playing out in court in a very interesting way. But this time around, outside of the courts and the documents that have been adduced, we do know, TV3 Ghana on Facebook, coming up next, the Office of the Special Prosecutor's Asset Recovery and Management Team has seized several items, including luxury vehicles, jewelry, weapons, and documents relating to landed properties from the Trasaco residence of CEO of Gold Ridge Company Limited, Nanayao Dudu. Just for the benefit of those who know him with his alias, know him as Dr. Sledge. Now, the OSP seized the items, including weapons and these luxury vehicles and landed property documents, after a search was conducted at his residence earlier today. Yes. Now, we have some information on this. Dennis Pabewadam is staying with me a bit longer today for good reason. What do we know from the OSP on this matter?
Well, so the OSP is giving us an update on some investigations that he's doing. He says that Sledge is under investigation in respect of some matters, which he clearly details. That as part of the investigation, the Office of the Special Prosecutor today conducted a search at the Trasaco residence. His official name, Nanaya Ododu, known as Dr. Sledge, is Legon offices. The search, of course, he says, was under warrant. But what is important is the focus of the investigation, which the OSP clearly indicates as that's under investigation for suspected corruption and corruption-related offenses linked to Minerals Income Investment Fund. Remember this myth?
Yes. MIF, yes.
Yes, it has everything to do with the sky training.
Absolutely. So
yes.
This myth is more like an octopus. It has its legs in many areas, including this one, no?
So the investigation basically is on MIF. The gold trading. This specifically has to do with the gold trade program, which allegedly caused a loss of some $94 million US. Look at the figure involved.
94 million.
94 million US dollars to the states. So the OSP Asset Recovery and Management Team seized several items, including, you've already mentioned all those, luxury vehicles, jewelry, weapons, documents relating to landed property. So that's what we are learning. But Alfred, this is not the first time we are hearing the name Dr. Sledge in public conversation like this.
Yeah.
I mean, until recently, only people who operated in a certain industry knew the man Dr. Sledge.
True.
But for some reason, the Attorney General mentioned him within a context when he was responding to some allegations made against him as Attorney General. Let's take a listen to the Attorney General make those comments sometime few months ago.
I am reliably informed that his basis of saying that I am corrupt and a thief is that I took campaign contribution from a businessman at East Legon known as Dr. Sledge, and that he also knows the people who donated pickups for my campaign. Now, ladies and gentlemen, if receiving donations for your campaign or getting a pickup for a campaign is thievery or corruption, then there are 276 thieves in Parliament, including the person who was making the allegation himself. But let him be warned that in my hometown of Zorungu, we do not fear mud being thrown at us. On the contrary, we walk into the mud to deal with the person doing the mud slinging. And I am prepared to walk into the mud with A+. Because what I have about him and the National Service scandal, he should come and tell you. I'm challenging him.
So that's the Attorney General. He was responding directly to A+.
Yes. So A+ had made allegations against him, calling him names. We can't repeat here. So the question was put to the Attorney General to respond, and that was how come he mentioned the name Dr. Sledge as being a businessman from whom some donations were taken for party campaign and all that. So it creates a sense, or at least it gives a fair idea of who this person we are talking about is in the line of politics and business and all that. But of course, Alfred, the OSP is telling us that tomorrow he will give a full update, as he had assured us last week.
Yes.
Two things to get an update on: that he has completed the investigations on the SML, and the SML, scandal in so many ways relates to the former finance minister, Ken Ofori-Atta. He also says that he's going to give an update on the packet for extradition of Ken Ofori-Atta, which he had indicated that by close of last week, he was expected to have given the whole docket to the Attorney General to facilitate the extradition process, which many Ghanaians are looking forward to. So indeed, tomorrow, the OSP says at 2:30 p.m., he will give an address to the state, and we will be there to cover all of that.
Certainly, and this is the notice that the office put out earlier today on this matter. So this is what we received, and take a look at this. This is the detail that Dennis, you just ran through, is captured in that official notification of this said press conference by the Office of the Special Prosecutor. Updates on completion of investigation into Strategic Mobilization Ghana Limited. And that's one of the subjects of investigation on Ken Ofori-Atta, is it not? SML.
Precisely.
The extradition packet.
Yes.
On former Finance Minister Ken Ofori-Atta. So we'll get to know the update.
And this matter is actually breeding some friction between the OSP and the Attorney General office. Attorney General doesn't seem happy at the pace of the work. OSP says that I have to take my time to tighten the loose ends and everything will be done. It looks like we are ready for that particular one. But we look forward to see what the OSP will say tomorrow in respect of that. And
so there's a lot to chew on and make a date tomorrow. We trust that will definitely give you extensive detail, comprehensive analysis of what the special prosecutor will say at this press conference beyond what you're going to be hearing anywhere else. So stay with us.
Okay, Abuja, we need a course of our political highway. So former NSA boss, and as you see, I'm granting bill with 800 million Ghana cedis. I had a home and prepare at the Bremer, but I must say, Kukutisa and some way at the MIA Ghana Politics Avenue. So, and don't forget to click on the notification bell. So, any updates be a better drop piano. Also, once a bit to me, Aka, Madam.